अगर कोई घर में एक पत्नी होने का बावजूद अगर दूसरा शादी करने का कोशिश करेगा, उनको 7 साल का जेल होगा। साथ में अगर वो छुपा के शादी करते हैं तो उनको 10 साल तक जेल होगा।
Assam's new anti-polygamy bill. Is it about a big reform or a uniform civil code push in that direction? What does India's matrimonial scape look like with such traditional practices? How it affects the society and what are the changes required? Assam has just passed one of the most significant marriage law reforms in recent years. But what does this mean in a country where marriage customs range from matrilineally to polyandry? Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh. Today we are going to talk about this marriage law reform that has been brought in Assam, but we are also going to discuss diverse range of customs related to marriage which are present across our country. So let us begin with the bill that has been passed in the Assam Assembly. Now this bill is the prohibition of polygamy, and this has a women-centric legal protection angle involved here as well. Here the highlight is that the Chief Minister has clearly indicated that it is not targeted towards a particular religion, and this is the whole idea to move towards and align with the idea of uniform civil code. Now when we talk about this bill in itself, let us understand that what is the whole idea and how it has fallen in place. So this bill marks up in the trajectory where we have seen the abolition of triple talaq, the bigamy laws under IPC have been brought in, and also the increased judicial scrutiny of the personal law practices that have existed. But if we talk about the India's whole societal fabric and the tradition, we have seen that there is a huge diversity which we will be discussing in detail. Now when we are talking about the prohibition of polygamy bill, it has penal provisions which provides imprisonment up to 7 years, and if there is a scenario of concealment of earlier marriage, the imprisonment goes up to 10 years as well. Apart from the penal provisions, there are provisions related to abatement where there are 2 years who allow, facilitate, solemnize any sort of such marriages which take place. So when we talk about this bill, the provisions here are to make sure that they are concentrated toward women-centric facilitation, and there has been a special exemption that has been given to the tribal areas which fall in the 6th schedule. For example, the Bodoland tribal region, Dima Hasao, Karbi Anglong, so that the customary laws which are in place in these tribal areas, they remain intact. Now this whole bill, when we talk about it, as we understand that this is a departure from the usual bills that have been brought out, so it becomes an important question to look into the legal and constitutional provisions. Now let us talk about the legal and constitutional provisions that are in front of us which facilitate the coming of such bills. The first one amongst them being the legislative competence, that if the assembly was competent to actually bring a bill like that. So when we talk about the entry 5 of concurrent list, we get to see that yes, marriage and divorces are part of it and state is competent to bring such bill. When we talk about article 25, we talk about religious freedom, but then we see the curtailment that it is subject to public order, morality, health, and also the fundamental rights such as right to equality, right to freedom. And then we also have Supreme Court judgments such as Javed versus State of Haryana of 2003, where it was clearly marked that polygamy is not an essential Islamic practice. So the essentiality test has also been already considered with regards to polygamy. Other than that, state can impose restrictions and it can be brought under the public interest as well. Other than that, we also have judgments such as Saira Banu, where it came in 2017, where it struck down the triple talaq and it brought constitutional provisions of Article 14, 15 and 21 in the right light. It also reinforced the gender justice over the religious explanations that have exist. Now, so the bill that has been introduced that follows the India's history of gradual social reform, removing practices to make sure that the public as well as social health is maintained, be it the sati pratha, be it the widow remarriage, triple talaq, etc. Now, when we have understood the legal and constitutional provisions as well, we have to understand that what are the challenges that lie forth in front of such bills. The first and the biggest challenge is basically the validity of the marriages that have been talked about. If we are talking that two marriages are not allowed, how do we understand the validity of first marriage? Because in our country, there is a huge data registration gap. Furthermore, there are cross-border marriages involved, so the jurisdiction of this bill would be limited. That would be a big issue. Another issue comes from the community, that the community might not accept this bill where there is informal polygamy which is socially accepted. So a lot of community resistance can be expected, and the effective functioning of whole of this bill lies on awareness and reforms. Furthermore, a big question is about the compensation authority, because if we want this to work out, there needs to be a proper effective functioning of the competent authority, of the compensation authority, so as to ensure that this bill delivers on the front it has been brought on. Now that we have understood this whole bill that addresses the issue of polygamy, now let us move ahead and understand, when we are talking about the diverse marriage customs across our country, what are they? Because when we talk about India, it is not just one matrimonial system, marital system that exists. It shows that different customs, different regions, different religions are the one which shape these customs, and other factors such as ecology, economy and structures are responsible for that. And that is why it gives us a fair understanding into that why states have to come up with different legislation. It shows us why there are exemptions to it, just the one we have seen in the Assam Prohibition of Polygamy Bill, and why uniformity, when we talk about uniform civil code, the first very thing is uniformity, why that is something very complex to address and manage in India. So the whole idea of bringing these customs to you is to show that the legislation would be different, the addressal would be different, and one size fit all approach would not fairly work out in India. Let us start with the first one that we get to see in Kerala. In Kerala, we have found the practice of non-sacramental union, that is sambandham, and matrilineal inheritance. That means property goes through the maternal line. So property is passed on through the mother's family line. And also residence is matrilocal. That means men visit wife's household and they are supposed to be located there. So this clearly shows that the unions that were made, especially in the Nair community, they were not rigid that we see in the present times, and gradually this also has evolved over time. So if we talk about the Nair Regulation Act of 1925, this went ahead and abolished matrilineally and moved the population towards monogamous frameworks that we see as of now. So it was the later and the large Thavard households, caste hypergamy, property consolidation, these were the reasons that we got to see sambandham and matrilineally in this particular society. And if we want to establish a context for what has been done in Assam, it clearly highlights that India's historical tradition from customary marriage to codified law has always taken time. So there has been always a gradual reform that has been brought in. We have another example which comes from Meghalaya, where we get to see the Khasi and Jaintia tribes, where matrilineally, yes, it does exist, but there is also uxore locality. And how does this work out? Let us try to understand that. When we talk about uxore local, it basically means that the husband takes the residence in the wife's house. In this situation, in this particular context, we have seen that the youngest daughter will be inheriting all the property, husband gets to move in the wife's home, and the lineage again is matrilineal. The lineage flows through the mother. So maternal uncle will have the major authority. The property would be siding to the maternal side, and this is again different from what we see in present frameworks. This is very important to understand because it shows that there have been women-centric customs as well. Furthermore, when we are talking about bringing common laws, especially uniform civil code, this will make it very complicated to put one size fit all personal law related reforms across the nation. And we have to already consider the 6 schedule exemptions that have been made that will always exist when we are talking about customs. We have more examples across the country, such as from the Himalayan region, where we get to see polyandry as well. We are talking about Zaskar, Todas, Kinnaur region, where we have seen there has been presence of fraternal polyandry, where brothers share one wife and one brother marks paternity through ritual that is done through a proper custom related to bow and arrow, which is seen in Todas. Now, when we are talking about this custom, the reason here is that the resource is very limited. There is scarce land and we do not want to get it split amongst, and that is why the property fragmentation is prevented through this particular custom that is carried out. And this also facilitates the family labor pooling, which is very much essential in the harsh climate in the regions that we are talking about. Furthermore, as of now, if we talk about it, yes, this custom has been seen declining, but it still holds its presence culturally. And when we are talking in relevance with the Assam Bill, we have to understand that it is not just polygamy, but polyandry as well. And both of these many a times come with economic constraints, and they are not related to religion. They are because of the situation what makes them. So the law must also consider the socio-economic angles here and try to address that, so that the change that we want, or the awareness that we want, or the reform that we want is very much facilitated. Let us look another example that is coming from Odisha, which we see in Kon and Bondas. So the traditional practice here is of human sacrifice. This is a practice which is known as Meria ritual, and the human sacrifice and also head hunting is seen in certain groups. It is historic, and as of now it stands abolished. But this custom is linked to fertility and also the clan rituals. So the whole idea of introducing you to all this, that over the time, yes, the relationship between that this exists between state law and customary law has been evolving, and it also illustrates that sometimes how harmful customs have been phased out through state intervention. So state intervention or state law, yes, it plays a very important role, but at the same time, when we are talking about varied customs, it becomes of immense importance to understand that why it has been brought in, to address the root cause and then bring in the reform to actually make effect in the reality. There are many more examples, such as when we are talking about Gujarat, we are talking about Bengal and also other regions. But the main conclusion here is that the Assam Bill that has been brought here, it is a huge reform which tries to bring in gender justice, which tries to address the constitutional provisions related to Article 14, 19 and 21. And when we are talking about the India's marriage landscape, it has a huge range, and that is why legislation lies with state as well, to make sure if there are social reforms needed, they can brought with state intervention. What are your thoughts on this? Let me know in the comment section. That was all from my side. Thank you so much.